It's been a wonderful session. So now moving on to the next session, may I request the members who are going to have a deliberation. So please can I request Shri PH Arvindh Paridanji, Venkat Kapasi ji, Ananth Marathia ji and Badri ji to please come on the dais. Yeah, welcome sir. So we'll quickly do the felicitation. Yeah, and Shalabh Daga ji, please. So we are going to have a very good panel discussion, I am sure, because the kind of faculties we have, they all are professionals and having different professional experiences. So I'll quickly introduce all the faculties, give a quick introduction so that we can move on to the session quickly. So first of all, I would like to introduce Shri P.H. Arvindh Paridanji. He is from Chennai. And see, all their CVs are running into the pages, so that I'll cut short and I'll just give a crisp introduction for all them. So, sir is having 30 years of experience and he hails from a family who is having a political family background, but he chose to be on his own legs and he started his own practice and he has done wonders in the legal field. He has been a corporate lawyer and a commercial lawyer for over 30 years. And he has been a former additional advocate general for Tamil Nadu as well. So he will give you a different perspective to this discussion. So may I request Shalabh Daga ji to please felicitate sir with a memento, please. Then the second member for this discussion, IP Vankatachalam Varanasi ji, and he is our own insolvency professional who has managed several insolvency matters, and the best matter which we all are aware is Sai Varda Power Generation, which is the first coal-based unit which was resolved. So I'm sure there won't be any situation which he has not faced during this process. So we'll get best experience from him. Yeah, Shalabh Daga ji, please welcome sir. And Advocate Ananth Marathia ji. So Ananth ji is having more than 19 years of experience in India as well as in Singapore. So he has done LLM from NUS Singapore. And he is also a smart lawyer. I have been knowing him since last 4 years probably. And he has also recently authored a book called Defaulters Paradise Lost. And I would say, Ananth ji, you are the person who actually taught us how to be present before the adjudicating authority and how to articulate our statement with milords at beginning, end, and center. Yeah, in that 50 hours training. So you have given that perspective. And with that, we have been able to conduct a lot of processes on our own before the adjudicating authorities. Yeah. Welcome, sir. And the moderator for this session is Mr. Badri, and he is a chartered accountant, a company secretary, and also LLM. And he has also managed several insolvency processes as an advisor. He has been part of the resolution applicants advisor. And yeah, and in the morning only I came to know that he's our own. I thought he's from Singapore because in Singapore he's conducted a session so brilliantly. He moderated a session. I thought he's from Singapore branch. Welcome, Badri ji. So absolutely, Sunit ji. Since you have called Sunit ji, I would like to say that Sunit ji, you have recreated the Singapore magic over here, and many congratulations to you. This has been a wonderful event. Yeah. So stage is all yours, and I would request all that take the best advantage from all these faculties. Thank you.
So we'll try to take a broad perspective from all the eminent faculties here, starting with Senior Advocate Arvindh Pandian, sir. Sir, please give us an introduction on it.
A very good morning to one and all. All my faculty on the dais and the intellectual participants here of the dais. It gives me immense pleasure and privilege to stand before you all, before this wonderful institution as such, as I call the premier institution of this country, which is a think tank for almost all laws to develop or evolve. Having said that, I won't take more than 3 to 5 minutes because I think with the time crunch, we will try to keep the discussion more rather than the academic side. So my endeavor is just going to be given outside perspective, though my job is to only present cases before the court. I thought, let me give a different perspective about how the industry looks so far as the IBC is concerned. So the myriad factors which I have found over a period of time is with regard to how which industry as such has had a restructuring more. We call it that insolvency law. I mean, it's an oxymoron. I mean, so much money is in insolvency. Everybody wants to do insolvency. And everybody is also remunerated because of insolvency. One good sentence which I would like to take from the previous session is that effectively the law is not to dissolve a company or liquidate a company, but to revive a company. So the conscience which we can take back with us is that we are not trying to kill a company to be a professional also, but rather to revive. Having said that, the challenge is what we have found, the latest one which has talked about region. I had a huge role to do it. When the judgment was given, I had argued the whole plan. I succeeded in the plan before the tribunal and it got reversed. I can only say fortunately, unfortunately, by the appellate tribunal. And I'm happy that the law is being discussed so much here. I'd like to leave it there since I'm appearing in the matter. I don't want to give more comments about it. So when I saw the sectoral distribution of this CIRP, if you see the admission level itself, the manufacturing and real estate stand out a lot. This is IBBI's latest quarterly report which has been given. So in effect, you will find the power sector, electricity is a small one, but the amount of law they have developed. So if you look at each one, now other than this, the service sector has not been taken into account because services sector basically goes into a different part of the GDP. So this table will show at the admission stage how many distribution areas are available when the matter comes before the adjudicating authority. Compare it with the appeals or reviews settled or withdrawn. So at the entrance and at the exit. At the exit also it doesn't seem to change because you will find again the manufacturing and real estate almost taking 53%, which is more than half of the, I would rather say, the economy insofar as IBC is concerned. And you will find the same ratio with regard to other industries. I don't want to really concentrate on one. But I would like you to also see this hotel, which is a small yellow one, where we have this unique concept of reverse insolvency or project insolvency, which has developed, again judicially developed. So therefore it doesn't owe its existence to the code. So that's one area which we need to see. So hotels along with construction would have a complementing there. So this is when the CIRPs result in an appeal or a review or a settlement or a withdrawal. Now at the plan stage, so before even that happens, how many go into plans? Now please see the manufacturing sector, how much have gone up. It's another whopping 13% over and above the actual 36% which filed. So that shows that the economy has a huge revival at the manufacturing level. So the plan sanctioned by NCLT or the appeals confirmed, you will really find that half is the manufacturing sector. And you will also find the real estate sector again coming with another 13 and another 10% going to virtually others. So you will find that the country is having a real revival in terms of the, not just the interference, but the overall supervision of the NCLT is what I would say, because it's not a judgment which we go for, it's not some kind of a litigation which we go for, but for a restructuring, which used to be under 230, 234 of the Companies Act, which used to be 391 to 394 of the Companies Act 56, finding its place through the IBC instead of the SICA also. Having said that, commencement of liquidation, if it didn't go into effectively the CIRP process vis-a-vis the resolution process, where did they end up? And again see the numbers. It's a bit encouraging because instead of 49% which got resolved, it's only 42% which went into liquidation. And in this, I couldn't get the numbers. How many were actually not asset sale, but actually a business sale? So that will show also, has there been any revival insofar as the business per se? I would rather give half here because nobody was willing to buy just pure land play. It did have a value also. So if they couldn't take or couldn't get the cross-cuts what they wanted through the plan, but they wanted to take the business through liquidation, I would at least give half of this number. So which means add another 15% to 20% to the already existing 46%. You had 66% effective revival of the industry. So for once, lawyers are speaking statistics, so you should go by the numbers given by IBBI. So this is a very positive picture in my view of how the sectoral distribution vis-a-vis CIRP or the liquidation or at the start of the CIRP or at the end of the CIRP leading to a review or a withdrawal is with virtue of numbers. Now here we find an interesting number again in the yellow if you see, wholesale and retail trade. I'll just take another 1 minute and I'm done. That seems to be suddenly coming out from somewhere because that would be more or less in the service sector. Now, the wholesale or retail trade is not effectively a manufacturing sector in my view, subject to what the industry experts would like to add during the discussion. I find that as a new one because if that is put into the service sector, this I would give the credit also to NCLT because they have been able to see its revival through in some form of liquidation because it wouldn't effectively have only again a land play. So all these numbers I had taken it from the IBBI to just quote, and I'm not quoting it on my own, I have not done my research. So this effectively in a nutshell is a glance. I've left the presentation with the institute. Anybody who would like to use it also can use it. I've given some explanation for each of these also at the back. So having said this, I would like to save myself a little bit on law, if at all, if there's anything which you would like to maybe ask me during the discussion. Too much of case laws are available around. And on a daily basis, it's vibrantly developing. A case law which I use on the first day is not a case law on the next day. A case law in Delhi is not a case law in Chennai where we argue. So having heard it, I would only thank the institute once again for giving me a chance to first read, understand the industry before coming here and then making a presentation to you. Thank you very much.
So it's very unusual for us to see lawyers speaking statistics. So we are glad that you are here. Now I'll request Mr. Vankatachalam to give his views.
I have come unprepared actually. I have come from Hyderabad, and when I thank at the outset the IBC committee of ICAI and the Ahmedabad chapter of the ICAI, WIRC of ICAI. When Sunit Shah called me and told me that you have to come to Ahmedabad to share your experiences and your challenges which you faced during CRP of 2 companies which I have dealt successfully, I was elated actually. The reason being, it has brought back the moorings which I had post-graduation, which I spent from 83 to 89 in Ahmedabad. And the first sentence in Gujarati I have learned here in Ahmedabad. I just take 2 minutes to explain why I say that. Because after completing my CS from Ahmedabad chapter of Company Secretaries here, when I was given internship in GIIC, Gujarat Industrial Investment Corporation, Company Secretary was Harshad Bhai Shah, and his PA, Kamla Bain, was never used to be in the seat. And each time as an intern, I used to attend to all the calls. So when the calls come, everybody speaks in Gujarati, and I didn't know how to reply. I used to just put on the phone. Then one Punjabi guy was there, he told me, you simply say, Kamla Bain seat upar nati. So that is how I picked up my Hindi, And then Elisha College was a place where I have done my law. And costing also in the Ashram Road, there used to be a chapter, ICAI chapter, from there I have done it. Now, we are going to anyway have panel discussion on 2 companies which have successfully resolved. One is United Seamless Tubular Private Limited, and the other is Sai Varda Power Generation Limited. Both the companies for which when I was appointed, in 2017 when I was appointed, the IBC was at nascent stage. And a resolution professional is as successful, as effective, and as efficient as his team is. And I was really fortunate to have a barrage of chartered accountants and lawyers to support me in my implementation of the CRP process in these two companies. And one of them is Badri Narayanan Iyengar, here who is staying here, who is a chartered accountant and who has helped me a lot. And then I knew the value of a chartered accountant because I am a company secretary, but I can tell you, in the back end, it is the chartered accountant who does the job, and in the front end, it is the lawyer. So without both of this, any CRP or any insolvency issue cannot be sorted out. So we'll have more in the discussion. Thank you.
Thank you, sir. So now we have AA, an author and an advocate, Mr. Ananth Marathia. He'll share his views.
So a very good afternoon, one and all. My co-faculties on the dais and the learned audience. First of all, thanks to the Institute for this amazing opportunity. It's always nice to be in Ahmedabad. It's a very, I would say, very welcoming city, very welcoming people. Thank you so much. In fact, I was telling someone that the reception that I've got is more than what I thought I would. So thank you so much. Quickly, so I will then, since Mr. Pandian has already referred to some of the data, at a broader level, I'll give a broader perspective and focus on a couple of sectors. About 7,000, I will speak mota-moti numbers. 7,000 CIRPs commenced as on date, out of which about 4,700 CIRPs are closed, settled, reviewed, resolved, one way or the other. About 897 out of which have been taken by resolution by 12A, which means the promoter wants his company back, one takeaway. And about 720 resolution plans. And over the years, the numbers have been increasing. If you see, there's been an overall continuous increase in the number of admissions per se, the number of filings also. But year on year, 24% filing because new law, obviously now, then eventually there was a bit of a drop also. But IBC is becoming an effective debt resolution mechanism, and it's not the olden times of your BIFR where things are on for years and so on and so forth. Recovery rate, somewhere about 31-32%. It dropped from 43% because initial 12 accounts, 15 accounts, the big accounts obviously gave slightly better recovery rates. MSMEs, SMEs, obviously there's a challenge. So about 31-32% is the recovery rate. Sectors we've already seen in the previous session, but yeah, previous presentation. But yeah, manufacturing and real estate put together are two key sectors which pretty much are the maximum companies suffering in this. Now, manufacturing sector, interestingly, has the second highest rate of approval of resolution plans. Liquidation is on the higher side. Why does manufacturing sector suffer? We will discuss in the panel discussion, but you have to bear in mind that there are a lot of factors. In fact, we can have a 30-40 minute discussion exclusively on the manufacturing sector and their challenges, why they suffer, what are their issues. Look at it also from the industry perspective. Unka kya perspective hai, unke kya problems hai. As professionals, we see it from the perspective ki haan, theek hai, how do we go and help them? But understanding their mindset, their vendor issues, their other issues, not getting the supplies in time, global chain disruptions, global events. Real estate is another sector where there has been a fair bit of activity. Out of 78 plans out of 611 approved plans are in the real estate sector. Few interesting things that have happened over time, proposed changes that are coming in, fast track resolution exclusively for real estate, more of AI to be used, project-wise insolvencies already get the blessings of the courts. Of course, these are the other sectors. I'm keeping a little quick because rather spend more time in the panel discussion. Interestingly, in the construction sector, the resolution is to liquidation ratio is 1:2. So one company which is having a resolution, you have two companies which go into the liquidation. This was something interesting I found, apart from other findings. Wholesale retail sector, where actually there are, going back to wholesale and retail, about 10% of companies which go into that CIRP. See, there are challenges with respect to this. This is another one very interesting sector, less spoken about, but your brand value, whether it can be revived after CIRP, why will someone want to buy your company? If it's a wholesale company, how are you affected by global supply chains and other issues? If you're a retail company, going back to again a post-pandemic, can you come back? Do you have tangible assets, or is your brand your only asset? Do you have inventory? Why should somebody come and acquire you? A lot of things are there which can be discussed. So yeah, possible attractions could be a dedicated client base, long-standing. But today things are changing. Every 5-7 years, the world itself is changing at a pace where today, as we call it, I learned a term called, I think, Generation X, or I don't know what, millennials, Generation X, Y. I don't even know after 5-7 years how each generation is taken as something different. So yeah, things are changing. Let's see. Power sector, as a less spoken sector, but actually has seen a heavy amount of litigation, cost overruns, delays, tariff issues. So again, see from their perspective, they have their own challenges. Simple thing, your EB board doesn't give you the money, your government EB, whatever, the respective 500,000, 2,000 crores, but your bankers are behind your life. Isn't it a little unfair? That's something which is worth possibly thinking about. The larger picture, again, about 31% recovery rate, 632 plans, more in the discussion. And as I don't know too much of Shairi, but I like this movie Guru, which was made on you know who. And in that Guru movie, Abhishek Bachchan had a very nice dialogue, which I will give to Badri. Ki boss, you gave me a 6-minute timeline. 6 minute का समय दिया था, 5 मिनट 20 सेकंड में खत्म किया है, 40 सेकंड मुनाफा. So that's how it is. Thank you so much.
Thankful, sir. Thankful for that. So, first of all, thanks to the Institute and Ahmedabad branch for allowing me to moderate this session. So, they say asking questions is very easy. It is. But when you have such a panel, a senior advocate is there, Mr. Vankatachalam, a successful IP, and an author sitting with me, when I draw them some questions and give them, and they are like, just ask whatever you want on the stage. Then it becomes more difficult for me to choose and ask what I have to ask. So you made it a difficult task for me, the entire panel. Right? So I'm going to pick and choose because of short time. So Pandian sir, starting with you. You have seen different perspective of various stakeholders in various sectors. So can you just give broad challenges which different stakeholders face in different sectors?
Well, it's a very hard question actually. It was quite easy to give the statistics, what is available. So when it comes to a case, I have a very, very bad habit. I don't remember the name of the client at all. And I don't remember also which sector he comes from. Unfortunately, because we do about 3 to 5 cases a day, we are stuck more into the issues. We are stuck more into the rule. We are stuck more into the legal issue which is involved. And halfway down, suddenly they give a name. It kind of really pushes. But to tell you very honestly, the statistics, I'll give you something which I found in law. I was a person born under the Companies Act 1956. So the winding up provisions of the 56 Act seems to me my bread and butter. And then SICA was a little bit, but because it was practiced in Delhi, we didn't have much chance. But the number of case laws you have under the 1956 Act, Companies Act, either operational mismanagement or winding up, from 1956 to 2016, when the IBC came in, double the number of judgments have come in IBC from 16 to 23. And all I mean it are Supreme Court, not high courts or others. Because a case to land in Supreme Court requires 2 things: issues and the stakes involved and the power of a client to fight based on the cost involved. So imagine from 1956 to 2013, the total number of corporate litigation which went all the way to the top. But between 16 to 23, the number of cases, which is double, shows the amount of not just interest, the value of money involved, number one, primarily, and secondly, the stakes involved in the form of legal interpretation. So starting from Swiss ribbon up to date, almost all case law got developed in regard to every provision of the Act. So I would not like to give the credit to any particular sector. I would like to give the credit to the whole IBC as a whole. And actually, we should be thanking Supreme Court, because Supreme Court always is more a welfare-oriented institution. They don't have time to take up individual corporate issues. If I may use the word privately, which some of the judges say, all you private people have enough money and other things to run. I don't think we have time. We have a common man who's in the jail, who has to come out, whose property is involved, whose constitutional rights are involved. There's no time. But suddenly they have found themselves at least 3 to 5 benches touching upon this. So I don't want to give any particular sector this benefit, but the whole IBC has to be given the credit for this.
Thanks, sir. You have touched the ecosystem basically, that the ecosystem is evolving, and as it evolves, the challenges will be there. And that's getting decided, and judicial prudence is getting built up with over time. So coming from an IP's perspective, sir, I think Vankatachalam, sir, you were one of the first to resolve thermal coal-based power plant in India. So what power sector challenges did you face or see, and what are the takeaways for you?
Yeah. It's a very difficult task, because that was at the nascent stage of development of the IBC. And first of all, we do not have the domain expertise. So when we had to take up the matter, first we had to find out what are the challenges facing the power sector itself. So the regulatory environment is one of them. And as already they have shown the recovery of dues from DISCOMs. And in CIRP, the power generation limited, which we have resolved within 1 year, within 270 days, from 18 to 19, October 2019, there it was typically a captive power generation plant. So first we had to understand what are the legalities involved in it, what are the legal provisions to be eligible or entitled as a captive power plant. That is 51% should be utilized by the captive group powers, and they should have a shareholding of 26%, to understand that. Then apart from that, see, whatever earlier under the only single organization, state electricity boards used to do all the generation, the transmission and distribution. Later on, after the Electricity Act 2003 and all that, they have been divided into 4 companies. One will be a holding company, then there will be a transmission company, there will be a distribution company and a generation company. So we had to deal with different regulatory authorities, and one of the issues which we faced was the transmission, because the dues were not paid. The open access which we had from MSCTCL was discontinued and scheduling was stopped. So at a time when we are trying to revive the company, we have taken the responsibility of reviving the company, this sort of a thing affected the going concern. So then we had to appeal to NCLT saying that this is a critical, transmission is one of the critical things for a power generation company, and if that is stopped, we cannot generate a revenue model, or we cannot generate even the power also. So NCLT Hyderabad at that, even before 14(2)A had come into picture, they took up this matter and ordered in our favor, and that is how it started the process. So challenges are more because of understanding the technical jargon involved and multiple stakeholders.
Ananth sir, before I come to you, just one more connecting question to Pandian sir. So like Mr. IP said, that going concern gets impacted when there are attachment of asset or suspension of licenses. So IPs deal with a lot of statutory authorities, right? And we see a lot of cases where ED, SFIO attach assets, or bank accounts are frozen, or like this, like open access is cancelled. So how do we sensitize the stakeholders to ensure that the going concern objective is protected?
In the last 6 years, I should say that the stakeholders have got themselves sensitized tremendously. In the beginning, they were thinking like any other government agency, we can go and file a claim at any point in time, it will get condoned, and we being a statutory authority, our money stands at the top. And when they were really shown their place, that creditor's right is what is this act and you are the last, you're even below the operational creditor, that really hurt their ego tremendously. There was a huge tussle going on between in the government itself, between all the other regulators vis-a-vis the MCA, whether IBC should have that kind of primacy. But thanks to again the NCLAT and the Supreme Court, almost all judgments ensured that stayed. Now we know that almost the moment the advertisement comes out or a publication is made, the statutory creditors are also the ones who file at the earliest. So the electricity boards or the GST department, the income tax department a little bit, most of them are now sensitized to that great extent. So far as the criminal matters are concerned, where they may fall under the attachment of either the SFIO or the Enforcement Directorate or other entities, now they have their right only touched upon when a plan goes through or in a liquidation. So prima facie, until the criminal cases get over, the question of seeing the attachments go away are not there at all. So that's why IBC brought 32 capital A, to ensure that along with the property, the attachment won't go to the new purchaser, but it stays with the promoters as such. That's a huge development. So to a great extent, yes, I should say. And now, because in the beginning itself, the RP is supposed to send the notice. Earlier, it used to be the advertisement and calling for claims like the old official liquidator. Now, the moment it comes and the settlement of claims is accepted and he sends to all the other creditors, also in the books whom he feels should file a claim, departments are a bit proactive, I should say. It's actually good. That has seen a good change in my view.
Thank you. So we've also seen judgments where courts have held that different statutes should be harmoniously interpreted.
Yes.
If only something is inconsistent with IBC, will IBC prevail? But if there can be a harmonious construction, you should do that. So coming to Ananth sir, just touching upon the behavioral change, he was talking about the stakeholders. So what do you think IBC has brought in, as a behavioral change among creditors and corporate debtor, promoters of the corporate debtor?
Yeah. So basically, as far as the promoters and the corporate debtor is concerned, I think we need to understand the fundamental ethos. The promoter in this country is emotionally extremely attached to the business. It is not that easy to let go. Let's start at a very basic fundamental level. At home, when the child grows, is it so easy for us to throw away the toys of the child, though the child grows? We want to hold on. Take it back to now to the corporate level. So to begin with, that was a challenge that the promoters were facing, and till date we see at the final stage, resolution plan has been approved, everything happens, then one typical 12-way proposal comes, so on and so forth. But by and large, yes, promoters have tried saving their company. Data shows about 40% of the companies are one way or the other taken back through the whatever resolution plan, or it could be your settlement or whatever by the promoters. They are settled and closed. So that's one thing, which shows that one, there is a sense of fear coming in, there's financial discipline, more accountability, but at the same time, this should also not kill the entrepreneur spirit. End of the day, you have to take risks, and as you know, the way IBC initially, there were some discussions, failure of exit and the failure of failure, I mean, the fear of failure, I would say, should not even be there. That's okay, you fail, you move on in life. So the entrepreneurship should not get affected is at least something which I feel. But at the same time, for the creditors, they also need to understand this, as in the morning session very beautifully, the objective of IBC is resolution and not recovery. It's been told enough number of times, but let's be very honest to ourselves. When a COC member sits, only focus is, mere ko kitna time mein kitna milega. They only want to see how fast can I get what. If there's a resolution plan which is taking a longer amount of time to pay the money and still revive the company in a better situation, they generally don't go for it. And one last thing is, in this, when we speak about behavioral change, I think it's time that, see, there are a lot of these conferences, discussions that are between professional groups. Then you have these chambers of commerce that they have their own discussions. I think it's important for a promoter to understand that IP is not somebody who's on the other side of me. IP is also an integral part, and I need to work along with him. So there has to be some kind of an ecosystem developed where promoters of businesses, SMEs and others, and insolvency professionals, they come on common platforms, share issues, so that mental block is slowly removed over a period of time.
Thank you. Vankatachalam sir. So everybody here knows the Maharashtra seamless judgment, right? Which is that resolution plan can be at a lower value than liquidation value. And you handle the CRP of the company. So what are your experiences, takeaways, any learnings you want to share?
Well, that was the first assignment which I have taken, and directly as a resolution professional after replacing the IRP. So in that, thanks to your team, when we started the process, we had multiple, basically the challenges started with valuation, okay? So once valuation has been done by two valuers, the court has taken, even though as per law we have to take which is the minimum little gap, they have taken the higher one, which has gone, with that also we accepted it. And even then the resolution applicant gone along with that. Now, apart from this, in this company, there were several applications which have been filed against the RP, and we had to survive all those things. And when the plan was approved on 21st January 2019, right? But the handing over of the position could not take place because the resolution applicant got we have handed over the position immediately, but later on he got dispossessed and he filed an application for police protection. So that challenge was there. And then the litigation went on for 1 year till the Supreme Court has given its judgment on 22nd January 2020, asking the RP, that is me and my team, to implement within 4 weeks, taking the protection of police protection as well as the revenue authorities. So that was a really challenging task where we had to document every move of ours before we handed over the position. So when appeals have been filed against RP in NCLAT as well as in Supreme Court, Supreme Court has not gone into all those aspects, Honorable Supreme Court. They said now that whatever done, because we have complied with the law, nothing has gone against us. So what they stated is, now take the police protection and hand over, and which we have successfully done. So while handing over the position also, it was a huge task for us. We had to do documentation, take the police protection, change the security, hand over the keys, all the assets, and see that, because the factory was not in production from 2015. So to ensure the, because we were not in position during the intervening period, but later on we could successfully implement the order of Supreme Court.
Since we were closely involved, so also we need to understand the trigger points in insolvency. So it's always market linked as well. So power sector will have your environmental clearances, maybe government policies, and this particular case was linked to your oil and gas industry. If there was a sluggishness in the oil and gas industries, so this company used to make seamless pipes, which used to drill in the ocean to get oil and gas. So if there is a sluggishness in the oil and gas, you won't have demand for this product. So that also triggers insolvency. So we have to understand all those factors as well. So touching on valuation, because this case was closely related to valuation, how do you see that fair value, liquidation value in CRP and realizable value in liquidation scenario? What is the role of that valuation and how should creditors approach it? Your brief perspective on that.
Sure. So without getting into the law, regulation 35, you appoint two valuers and then the significant difference of 25%, you go to the third value. That's the law. Practically, what's important is, first of all, what is distressed value, what is liquidation value. That's distressed value when that's the bare minimum you should be getting. And a fair value is something which you should be getting at something at an arm's length distance, a fair transaction, so on and so forth. I will rather focus more on the two broad types of businesses, brick and mortar businesses and your new off late, the unconventional businesses of information technology, IP, IT and all of that. See, brick and mortar businesses, evaluating your assets and so on and so forth, it has certain parameters, you go about it. Of course, the value of the assets deteriorate over time because the processes take time, but still we are relatively in a better position where within 2 to 3 years, one way or the other, you will get a value for your machinery. And let's be realistic, by and large, what is the loss that happens with the value of deterioration with the machinery, plant machinery and the shed, typically in a larger manufacturing unit, it's offset by the value of the land that goes up. So that kind of valuation is still okay. The larger challenge is it valuations with these new, the new type companies, information technology, IP, IT, what do you value? Because most of them don't even value their own intellectual property and keep it as, a repository of what is the valuation. If an IT company or an IT ES company or a company which is doing anything in this sector or any service-oriented company, it goes into red, it goes into insolvency. Then what is it that you will value? Is it the client customer base that they have? Is it some intellectual property, some software that you can get from that company? Is it the employees? Because the first thing that happens is the company starts going into a distress situation, the employees start leaving and moving out. So they are actually one of your huge human capital. They are your, actually a capital in itself, which has a certain valuation to it. So that is a sector which, that whole type of new companies, and that's happening a lot today with a lot of these companies which go in that zone. So there has to be some kind of, I would say, possibly, I don't know, can we use AI? Can we have a system of time to time valuation of the new age businesses, like how you have your annual filings, compliances? Can there be a valuation filing of new age businesses? Some kind of a thought process will have to evolve. Ideally for both brick and mortar and for the new age, but definitely for the new age businesses.
Thank you, sir. So ICAI is working very proactively on valuation standards. So we keep having discussion, we have our view. So a lot of discussions keep on happening, and we have a IIIP ICAI also. So we are sure that, regarding the new complexities which are arising, we'll definitely be able to build some standard which can harmonize that. So Pandian sir, coming to you, how do you think ADR, possibly mediation or arbitration, can play a role in insolvency, probably pre-insolvency or even during CIRP process?
Yeah, it's a mediation or ADR as such. Yeah, I do agree it's a concept. I feel IBC is still not ready for it. IBC is still not ready. If it's a bipartite, yes, you are. Pre-admission, yes, you sit down, negotiate, send it, try it. But post-CIRP, it's a multi-party mediation as what you call under the mediation, I would say, the world. multi-party mediation has not worked even in land acquisition in our country. It's not so easy. You have to call the parties, negotiate the settlement. Like you will know very clearly in almost all states there is this metro rails coming. So whenever the land comes, how to get the land. So mediation has helped in those kind of projects where money is readily available. But when money is not on the table and you want to share a very less amount, so at the moment, no doubt, I was there at the Singapore conference. There was a specific, I think we had a session on mediation in IBC, in insolvency. Singapore and UK seem to be moving towards it in a lot of ways, but we can't immediately duplicate or replicate it in our country just because they have it. We need a lot of time. Even the group insolvency, which we are talking so much, I have my own, I would only say reservations about it. I'm not trying to say I'm not against it. We are still not ready for it. So, but the law will have to evolve. My answer for the moment will be that mediation has to be slow. We can't rule it out. We should not push it. We should just wait for it, because mediation started in 2004 in this country. I was trained as a mediator sometime in 2005. I am on the High Court mediation committee now for the last 10 years. And I did have my own experience of going and attending conferences, some training programs. So having that background a bit, for IBC, I think we should go a bit slow. That would be my view.
Thank you, sir. Vankatachalam, sir. So IP is expected to be an all-rounder. As a CA, CS or CMA, a lawyer. So when somebody is appointed, the suspended management, the creators, they expect IP to do everything on their own. They expect them to have the skill sets. How do you handle when somebody is appointed? How does an IP upgrade himself? How do you handle such situations?
Yeah, within the domain expertise, if he's a chartered accountant, he'll be good at finalization of accounts, audit and other compliances, the tax compliances. If it's a company secretary, he will have. But when you do in a when different domains are there, we'll have to develop a team and also discuss with, we ourselves have to study first of all, whatever agreements or documents are there. And apart from that, we have to discuss with the entire, all stakeholders, and then try to understand the topic and how to revive the company as a going concern. Okay, that is definitely a challenge. It doesn't mean that an RP cannot be an expert in all fields. So he has to develop a team wherein he can take the coordinated help of all experts and then evaluate for himself. That is how we should do it.
Right, sir. So, diverting a bit, sir. Ananth, sir, I'd like to ask you, MSME sector was, had a lot of impact due to COVID and on the consequences. What are the challenges which MSME sector faces? What are the solutions which are existing in IBC? And what way forward do you see for MSME?
That's a very wide question, a little difficult. See, the challenges for, first thing first, MSME is the backbone of this country, and I genuinely believe that 40% of the GDP comes from the MSME sector. They have their own challenges in terms of lack of access to larger markets, lack of access to, I would say, finance to some extent, manufacturing issues, conventional issues, cash flow issues, lack of resources to have a very organized structure. So that's the larger issue which we all know. Around the COVID time, 3-4 significant changes happened. Quickly, 1 lakh became 1 crore threshold limit. Obviously, the idea was to in some way safeguard the MSMEs. You don't keep falling one after the other as a pack of cards. Second one, your 10A suspension came 1 year at least. See, not that these were specific to MSMEs, but by and large, the MSMEs were the largest beneficiaries of these. 10A came, then your Section 240 capital A was brought in, where if you're an MSME promoter and if you're not a NPA or willful defaulter, as the case may be, and then possibly you can bring in your resolution plan. That was another relaxation that was brought in. So these were some things that were brought in for the MSME, but I think more is required. You need to have more, I would say, awareness for MSMEs, reach out to them, make them a part of your lawmaking thing, get suggestions from people who are at the ground level to see what is it that they are looking for, possibly give them more support. And as Sir was mentioning something very relevant, one man can't do everything. You were just mentioning about that all-rounder thing. I think the way IBC could evolve, like in arbitration, we have these experts who are expert arbitrators who come in for either construction issues, infrastructure issues, finance issues. With time, maybe IPs can choose to possibly become over a period of time, specialists in SME companies. They can be specialists in reviving steel sector companies, possibly wholesale retail, hotel segment. So once you do 2-3 companies of the similar sector, you automatically, the industry itself will absorb you in. The COC members will be more confident. Okay, this man has handled a CIRP of three of the same sector. Maybe why not the fourth one? And then your back-end team will also kind of start getting ready. And this will specially help MSMEs, because see, MSME is a very technically run, very closely held business. So when you have an RP who is backed by a team who's already done something similar in that sector, especially in an MSME zone, it really gives the confidence to the entire ecosystem. So I think that's something which we should try looking at, seeing if that can be developed with time.
So I've read your book, Defaulters Paradise Lost, and you've covered it pretty well, all these aspects. So it's not only a bare act reading. So you've touched upon some aspects which we want to know we've not done. And we are thankful that you've considered to give a special prize here for all those that are attending. Right? So since we are short on time and we should not disturb the next panel, my last question to all the panelists, starting with Pandian sir, is what are the emerging trends you see, sir, from a litigation perspective or a law perspective in IBC? Emerging trends, maybe 2 or 3.
Well, I as a lawyer, maybe I can say, I can't say like an industry perspective. We heard the Honorable NCLAT member mention that at the drop of everything there's an appeal, there's an application filed in the NCLT. For something and everything you find matters moving up all the way up to Supreme Court. And everybody keeps worrying how do we move towards reducing that. Because I can tell for myself, the amount of work it just brought like a flood for me. Like from January 22, I completely stopped IBC in NCLT. I said, I don't have time to do NCLT work. I'm just giving up. I'll move up only to NCLAT, and I've been concentrating on NCLAT. Now, NCLAT work is taken so much time that I am 80% at NCLAT. I'm not able to do High Court work at all or even think of even going to Supreme Court. The most important factor I feel will be the development of a law like the costs. We do have under the CPC costs. There is a provision under 242 for costs. The provision under the Companies Act 419 to 424, if you see regarding powers of NCLT costs. So if the principle of cost, like in the West, we want everything from the West. IBC is not fought by a common man. IBC is not fought for constitutional right. It is fought for taking over business. Therefore, the man who is trying to delay the resolution process, or the man who is being set up to intervene as a resolution applicant who has lost out, or a proxy operation creditor bringing appeals, to discourage them. In fact, I intend to prepare a huge note on this and give it to Mr. Ashok Bhushan, because if he can bring out rules, because they have said very clearly for NCLT rules they are planning. I am sure that if they bring out rules for costs similar to section 35 capital A under the CPC, you will have costs like 30 lakhs, 40 lakhs. So people will be very scared. And number two, professionally also, client won't think of not paying us higher, because whatever he is paying us is going to be added in the cost list, paid in check, not cash. It will be put in the list and be paid to the other side. In fact, in civil court for an Italian client, we had to deposit 60 lakhs right from the coffee and tea spent on the counsel to the client. I think this is one place if we are able to develop, then the litigation NCLT and NCLT vis-a-vis, not litigation, the wasteful litigation prima facie can be reduced is my view. And the other aspects maybe the domain experts can say.
Yeah, I think the standard operating procedures for COC would help the IP or resolution professional to facilitate the process. That is one area which I feel, because we always say when normally an IP, what he says is the commercial wisdom of COC, nobody can interfere. But if there is an operating procedure for them also to conduct themselves, it will make that much the task easier. Already the government is doing, they've done 6 amendments in 6 years, and the regulator IBBI has made 84 amendments, and out of which the 22 amendments have been done in the last 1 year. So that way things are taking place, and I'm sure, like the chairperson was saying, that there's no protection for the IP. There should be some sort of protection for the IP when he's being targeted without any justification. There could be workers going against the RP. There could be some criminal cases unjustifiably instituted. So that time, since he's a court-appointed officer, I would feel that there should be some methodology by which he can be protected.
Yeah, one aspect I think which should be, of course, emerging trends, I'll say most about something which we're not giving so much importance to, is the whole concept of pre-pack insolvency. You see, it's not picking up so much in India. And what's the reason for that? Off the record, I've been told by a lot of promoters that why my pre-pack is not being passed. And I know it's on camera, so I have to be a little conscious to say this. But the challenge is the bankers are scared to take a haircut in a mechanism, in a pre-pack outside the process, because they are end of the day answerable to the RBI and so on and so forth. So somewhere if this can be given an impetus, what's the point of running the whole process, going through the whole rejig, doing 2 years of some 20 interim applications and ultimately doing the same thing, getting the same haircut, allowing the value to get deteriorated of the assets, might as well finish it off in that 3 to 6 months of a pre-pack insolvency. But for that, the confidence that has to come from the banker side, they need some support, I think, from the government, number one. And number two, I would say more now interactions, inter-say stakeholders. We've always had one type of stakeholders interacting. I touched upon this earlier also. Like sir was saying, the IP versus COC is a perpetual issue that we see. I think now IPs and bankers need to start coming on common forums, discussing, coming up with some standard code of conduct or code of way of working, protocols, so on and so forth. Similarly, IP versus promoter. So some basics are, I think, put in place. And third, one last issue is, I feel overall, in the next 10 years, we will see that the quality of assets for which the loans are given, they would be better. Due diligence is better today. There is a bit more of strengthening of the legal lending system. So, but that result we are not seeing today. That we will see, I think, in the next 3 to 5 years, and that hopefully will mean that IBC has worked. Less number of admissions, unless of course we have another black swan event or something. But yeah, that's what I'm looking at. Thank you.
Thank you, sir. Thank you. So pre-pack, like you're saying, there should be a conflict resolution. People should come around together. So IMF and World Bank have suggested that pre-pack should discharge promoters' debt for at least MSMEs, because MSMEs and promoters are linked very closely. Discharge one and don't discharge the other, it won't be a success, right, sir? So thanks a lot for for your valuable guidance, valuable time, Pandian sir, Vankatachalam sir, Marathia sir, and it was a pleasure to moderate this session. Thank you so much.
My question to Arvindh sir, as you are a judicial expert, so what may be the probable reason or underlying the factors for the formation of a code in such a manner that oil get a maximum haircut? So as we have seen in many cases by the resolution plan or the liquidation, so maximum benefits will be taken by the financial creditors, not the operational creditors. So what's the major reason for this?
It's a very long question. Two words stood out: expert and haircut. Haircut I can't explain. So far as expert is concerned also, expert is a definition which I always keep telling, one who knows more and more of less and less. So I don't want to be called an expert also. So having said that, as a financial creditor, I exactly had the same doubt like you, till I attended and heard the perspectives of various other faculty also. The financial creditor sits on the COC to take care of his money, to take care of his plan value, how much of repayment. Yes, all of us look at it. How can he only worry about that? Why not the revival? Why not the other stakeholders as such? Now put yourselves in the shoes of that same financial creditor, which is my perspective. When he gave the loan, he appraised the same business. He is the one who lent that money, and so he knew that there was some value. And that is why he didn't give it just on the basis of the land or the security what was given to him. So whatever analogy or logic he had at the time of giving the loan, I would say is the same logic he takes it when he sits on the COC, because I need to get back the same money. So when he lent it, he had a logic or a justification, is the same logic. Now where do the operational creditors go in this? Well, none of us touched from morning till now, maybe in the afternoon somebody may touch. A strange situation will be a sugar industry. The farmers have now been treated out. I had argued it and lost before Madras High Court so far as through our own sugars, and now NCLAT has come out with a recent judgment which says that farmers who supply cane are to be treated higher because they have the statutory minimum price or the state fixed price as what they call, and they are supposed to only supply the cane to the nearest factory as per the government policy, where each state has its own one. So that's a I would only say outlier insofar as the operational creditors are concerned. But we are moving towards a situation where the law from 16 to 23 has been very financial creditor centric. Now other stakeholders how to protect I can see that developing. So yes, your question is a very valid one, but at the moment it's still only an academic one. The financial creditor role, in fact, in 1 minute, though I don't want to name the company's name, the clear case was, this plan does not repay our money very fast. That plan repays faster. So in effect, it was now a resolution plan is equal to a repayment plan, as what we call. I don't want to call it as a resolution plan. In an effective sense, it's a repayment plan. Whoever gives a faster repayment plan or a better repayment plan is what is favored by the COC. In today's sense, yes, the law is drafted in such a way that all the old NPAs have to come back into the kitty. 7 years, we've almost got 80 to 90%, whichever resolution they wanted. Going forward, I think time has come for them to start looking at other stakeholders to be involved in the COC also in the decision-making process, not post-liquidation like the stakeholders committee, but pre-CIRP process in the COC itself. That would be my suggestion. I hope I've answered. If there's any part to it.
Thank you so much, sir.
Ananth sir, as you said, to appoint the third valuer. So now how will the valuation will be done? Because if the third valuer is appointed, then the valuation of two estimate is to be done, closest estimate. So third valuation estimate is to be considered or first two estimate is good? Because in regulation it is that as the case may be, average value of as the case may be.
So that depends on a case-to-case basis. The third valuation value comes into the picture when there is a significant difference of 25% between value number 1 and value number 2. And when the third valuation comes, it should ideally be considered because that's there. But if that is significantly again different, or if it is tending towards the first or the second, then there is some kind of I think a midway or a common amount, this thing that has to be met. And if it is closer to one of the valuations, then that valuation can be taken as the liquidation. Because as the case may be, that is where it leaves, giving you that playing field to kind of take a call eventually as to how do you want to go about it.
Is least of the two.
Sorry, just to add to what he said, I would like you to read the judgment of Appu Hotels of Honorable NCLAT, which went up to Supreme Court, which is reported as M.K. Rajagopalan versus Appu Hotels, where I had argued the same point like what Ananth was saying, but explaining what this rule is, the gap between the first valuer and the second valuer, then the third valuer appointed or not, what are all the principles, NCLAT has detailed it. Though to that extent it has been reversed by Honorable Supreme Court, I would request you to read that judgment maybe to understand the principles of this provision.
I don't know if there's another session on buffet transactions, but with regards to buffet transactions, how is the jurisdiction leading to, what is the latest? Because we file a lot of buffet applications. Avoidable transactions. With regards to the avoidable transactions, how is the jurisdiction progressing? Once the liquidation is over, or when the resolution plan is over, after it becomes ex officio. So who takes care of the...
Well, in that context, I would like to read the judgment of the division bench of the Delhi High Court, which recently held in the Venus case, because the single judge, I'm forgetting the lady's name. Yeah, Venus, the single judge had said once it's part of the plan, all the puff transactions and the avoidance transactions don't get wiped off. But when it, on appeal, they've said if a plan provided for it, it must. You can't just like that say so. Having said that, that's one judgment which dealt with in elaborately, because that was being used by everyone in every NCLT to say that I have discussed in the plan the puff transaction, so it has to go. But the tribunal does not have time to take up many of these matters. See, they don't have time itself, first of all, to take up plans, leave apart even a liquidator's appointment or liquidation. So we are hard pressed for time. So these are the ones who have fallen at their last. So you have very few jurisprudence now developed insofar as this is concerned. You're right, because I do have a few cases also on the other side which say the promoter had only his wife and son and daughter as a shareholder. Now he thought that everything which was in the company is his. So he never took other than taking 50,000 salary and put everything into the company. Now when it went into a problem, you can't go around shooting at him saying that, look, his car is bought, his house rent, his driver was paid here. So we in India are still living in the time when the promoter thinks the company and him are one and the same. Not like where the US president gave twice the insolvency and came back to become a US president. There they have a clear demarcation, a Chinese wall between what is company's asset and what is personal asset. So we can't go faster from there. So if it's a listed entity where the promoter can be found for avoidance or I would say fraudulent or anything exorbitant as such, you prosecute it. But so far as private companies, I think the law should be a little bit slow, because he has ensured that he's put all his money, including everything, into the company, risking thinking that the project is bigger than his personal assets. So that, I do agree that there is a delay in all these matters. Having said that, there's a delay in every matter. That's my answer.
Yeah, just to add what Sir was saying. So yes, that issue is there. Matters are not getting heard. As Sir said, the admission matters itself is a priority to be heard. Resolution plans are top priority. And then obviously avoidance transaction comes at the end because it's not impacting your decision of the resolution plan. Legally, there have been regulation changes that have been made saying that a resolution plan should capture very clearly who's going to continue the POFE transactions, who will be the beneficiary, it should be the creditors committee, blah, blah, blah. I just think this is just a thought, and maybe this could be relevant 2-3 years later. Maybe I'm saying this ahead of time. Avoidance transactions bring in an aspect of, especially fraudulent, bring in an aspect of criminal intent. And therefore that they touch the angle of, criminal law and that kind of a jurisprudence they are backed with or they are associated with, which means you have to have a black and white answer. But maybe for private limited companies, for closely held companies at some point, can we look at mediation in such cases where the promoter and the committee of creditors, after the plan is approved, puff transaction is pending for 3 years, 4 years, if they can sit across with the blessings officially of the appropriate courts under some regulations which can be framed, maybe we look at it, but for that you'll have to move it outside the criminal intent angle. Otherwise then it will be, you commit a crime and then later you can do a mediation. But yeah, this is just some food for thought. Maybe we can take this forward and discuss this at some point.
Thank you.
Hello, sir.
The last question, please.
This question is to both Arvindh sir and Ananth sir. I mean, as a legal person, I think I face this question on a daily basis. When it comes to the delay in the IBC resolution process. So, from my business team all the time, I'm sure that you must have also heard the same thing. The two reasons that's been quoted is one, the way judiciary's approaches towards handling these matters, that is a slow approach, and the lack of capacity in the benches. What's your take on it, sir?
I'll put it in a very crude way. Okay, we always talk about delay, number of benches not being there, number of members. Now, all the three things we're talking about only because we want to take over a business. We want to buy a business or give a plan. Now, it is like saying, that's why I'm saying in a very crude way, a plan or a revival through NCLT or IBC is not equivalent to a first marriage. Okay, you can't expect everything what you want in your life which you envisage, dream about to get in the first marriage. You already know when you're coming for your second marriage, what is your expectation. This is what I will get. This is what is the time I'm going to have. So that having been said, you should be very clear that the system is going to give me this business slow. Do I have the wherewithal to take the interest cost for the delay? Do I have the wherewithal to go on appeals and wait till I get till the end? So never try to get a business from NCLT thinking that, no, I put so much money, I'm not getting value it's worth. Please, when you're coming there, be prepared for everything. Even be prepared to forfeit the money. It's a risk you're taking. You can go as well and start a separate business and go fast. You want to have an inorganic growth and you immediately come here. So that's why don't blame the system. I think the government's best thing in my view from 2014, this government when it came, the best thing to happen is only IBC in my view. As a lawyer, what I've seen. And that has really changed in the morning also. My colleagues were saying, it has changed the lending culture. A person who takes money is scared now without being said that he doesn't want to repay, go to a civil court, it will take 10 years. No, the fear is there. Having said that, so for plans, as a legal team, I know you do a lot of M&A in your company, a lot. So your philosophy should be, don't try to push it timelines. Don't try to say next adjournment is coming. If it doesn't happen, my management or my promoter is going to say, get it fast. No, there should not be a timeline in this. You should have a rough ballpark of plus or minus 2 years, I should say, not 2 months.
I think you've captured it very well. So I don't want to. I
I think sir thinks he's captured it very well. I don't think I should add anything to it.
This I'll ask fees, okay?
So, sir, again on the ED part, which Badri touched upon.
Enforcement.
Yeah, the attachments. So, you also mentioned that 32A is there to protect the rights of the eye, subject to fulfillment of ANP surplus.
Yes.
So, sir, we have also seen that ED has been fighting that 32A with different courts, and there's also one open case with Supreme Court, which is, I think, coming next month of motion state. So, in such cases, sir, how do you think the RA should proceed? Like, should it take shelter of 32A and give the plan, get it approved?
Yes, I think you should not. One good thing about IBC is you shouldn't be scared of the regulators at all, or even the enforcement agencies. They can't do anything to you as long as you don't have anything else to hide. If you as RA who are coming in, and you don't have the fear of, I mean, unless they already have, there are some red line companies, when you touch them itself, you get a shock. So in that kind of companies, unless they are not in that radar, absolutely you're right. Please go ahead, place your plans, push for the approval, because NCLT has got the power of 32, and to my knowledge, no NCLT is taking away their hands because of the fear of enforcement directorate or so. They sanction the plans. They say that whatever it is, the promoters are going to get the fire of it. You will ensure that you will get a clean company minus the prosecution which won't follow you. I think you should proceed.
Thank you, sir.
Pleasure.